All right, good morning, everyone, and thanks for coming for the release of the latest report around the Nagoya Protocol that Professor Bagley has graciously agreed to dive into these issues. We put out our first report on Nagoya, I guess it was two years ago, actually, and we became interested in the Nagoya Protocol through our synthetic biology project, and this issue of when you start digitizing DNA, how does that actually start impacting researchers, industry, and particularly at the international level at the UN. And it was particularly salient at the time when we first did this report because we were getting close to the sort of magic number of countries that needed to ratify Nagoya. And then lo and behold, not too long, a couple of months or so after we published that report, the Nagoya Protocol was ratified. And since then, Margot and I have had I won't call it the pleasure, of being part of a lot of the Convention on Biological Diversity discussions at the UN in the SUBSA, which is a subset of the member states that are supposed to focus on the science and technology issues, particularly of new and emerging issues, one of which is synthetic biology that the convention has been discussing and dealing with for a number of years now, to the point where originally there were moratorium languages that now has sort of moved away. And then most recently in September, they formed an ad hoc technical expert group that really was charged with diving deep into the issues of synthetic biology and had a list of charges that they were supposed to go through. I'm a member of that ATAG, and unfortunately, Nagoya, we kind of punted that issue, mostly because it's quite complicated, as Margot will explain through the great research that she's done. But I just want to sort of read off. So the ATAG report actually just came out last week for that, or at least officially became open for public comment. So I encourage you to go to the UN CBD and download the ATAG report and submit comments that you may or may not have. We did our best of trying to get through the charge that the SUBSA gave to us. But I just want to kind of read off to you a couple of the points that around Nagoya that made it into the ATAG report. And actually, maybe I don't need to necessarily read them, but I guess the takeaway is that around that table of experts, there was no real clear path in terms of how to actually deal with the digital nature of DNA as it relates to the access and benefit sharing of genetic resources. The Nagoya Protocol, when it was first thought up and written, really was talking about the physical removal of genetic resources from in countries. So this was back in a time when technologies, particularly the ones we see today, didn't necessarily exist. And really what was happening was companies or researchers or prospectors were going into country and physically removing species, usually, or plant varieties and those types of things. The current state of affairs now is that you quite literally don't ever have to step foot into a particular country, and you will have access to particular genetic sequences of potentially indigenous species that come from those countries. Because as you digitize sequences, it becomes available on the web. You can download those sequences and then actually have them synthesized without ever stepping foot in that country or even potentially knowing where those came from. So that's the context that we asked Margot to sort of dive a little deeper into, and also explore some of the other international treaties that are also struggling with digital DNA around issues around IP and patent issues. So with that, I'm going to pass it off to Professor Bagley and thank her again for taking on this no small task.
Thank you, Todd, and special thanks to the Wilson Center for commissioning this report and facilitating a discussion of these really interesting and important issues. As Todd mentioned, this is a follow-up to a report that I co-authored in 2013 with Artie Rye on the Nagoya Protocol and synthetic biology a look at the potential impacts. And in that report, we focused really on the interplay between synthetic biology and genetic resources as it's been defined in the Nagoya Protocol and its relation to the Convention on Biological Diversity. And we looked at just a select few of the implementation issues that are unresolved with the Nagoya Protocol. And as a result of that, that led to this new report, as Todd mentioned, where there were some additional questions that we thought needed to be explored. I really enjoyed working with Artie so much. I was very disappointed when she was unable to work with me on this new report due to other commitments. But I really appreciate her input as well as that of others who are mentioned in the first footnote in the report. I've got a long list of people in there, of course, even more that are not in there, who contributed in terms of thoughts for the draft and just conversations really helpful. So this report, this is basically the table of contents. There's a basic overview of synthetic biology, a bit about synthetic biology and intellectual property protection, some interesting questions that are arising there. And then looking again at the synthetic biology and the Nagoya Protocol use and potential misuse of digital information. What I'm not going to focus on so much in my remarks, but I'm happy to talk about in the Q&A afterward is synthetic biology, Nagoya Protocol, and intellectual property treaties, which is more the TRIPS aspect and whether Nagoya and TRIPS, whether there's really any conflict there. I already have too many slides, and so to keep it to a manageable amount and be able to get to the Q&A, which is really, I think, where we want to go, I'll just not talk about that. And then possible future treaty-based ABS and DO, access and benefit sharing and disclosure of origin obligations that are being discussed in the World Intellectual Property Organization, that's WIPO, their Intergovernmental Committee on Intellectual Property, Genetic Resources, Traditional Knowledge, and Traditional Cultural Expressions, and how that might ultimately impact synthetic biology researchers. I don't think I need to, well, I think there's probably a range of expertise in this room in terms of synthetic biology. But just to put everyone somewhat on the same page, no, there's no set definition, but we can think of it as creating standardized biological parts and using those to assemble into more complex modules and performing a variety of functions. There's top-down and bottom-up approaches with bottom-up approaches tending to focus more on fundamental issues of designing and establishing the principles for these modules and how to build systems from raw materials. Top-down, seeking solutions to existing problems by perhaps modifying existing organisms or DNA sequences. I've got a couple examples here of interesting developments that we've seen in the past year or so, expanding the genetic alphabet, developing new base pairs, X and Y, to add to the traditional ones that seemed like it was all we could have, and the possibilities that these new base pairs, new chromosomes, could lead to new proteins, new cures, variety of possibilities with synthetic biology. And more of a top-down, producing a morphine precursor, the bane, from DNA sequences from a variety of species, plant species, rodent species, and coaxing yeast to produce this compound. So lots of interesting things happening while, and this is from 2013 Wilson Center, map of synthetic biology. Most of the research is taking place in the United States. More and more is taking place outside of the United States, and more by a wide variety of entities. Of course, most still with companies and universities, but the number of entities involved in synthetic biology research is increasing over time. One of the reports that was available, it looks like all of the copies of that. Okay. All right, so there's still more. A report that just came out a month or so ago by the Wilson Center looking at funding for synthetic biology, in particular looking at U.S. government funding, which has also been increasing. One of the interesting things is that at a different Wilson Center event, there was a discussion of the increase in private sector funding for synthetic biology. And it was noted that so far this year alone, there's been more than $500 million in private sector synthetic biology funding. So a lot going on in terms of government as well as private funding. One of the interesting aspects of synthetic biology are the creation of these modules and this open source aspect to it, that you can access modules that you can use to create or modify the functions of organisms to do a variety of different things. And this availability of these parts has really facilitated the growth of a do-it-yourself community in synthetic biology, which I think is well exemplified. Oh, that slide is not there. Okay, it's completely missing. All right, I had a slide, sorry, that didn't appear, of an iGEM team, so the International Genetically Engineered Machines competitions, and this was a team from the University of Virginia, where I teach, and their NIGON project. And it's really amazing the kinds of things that these students from around the world are working on, and it's not all pie in the sky. I was at a meeting where a researcher from Cambridge was talking about an iGEM project that was leading to a cure for dengue fever. So this availability, easy access to parts facilitates the dissemination of knowledge and the possibility of new creative endeavors. And that has led to somewhat of a divergence in the synthetic biology community regarding synthetic biology and intellectual property protection. Now, patent protection is still the predominant type of protection for synthetic biology inventions, and that's not likely to change. But there is a community of proponents of open source synthetic biology that are interested in possibly other kinds of protection, in particular copyright, and whether copyright might provide a better source of protection for synthetic biology inventions in particular, at least some of them, looking at the analogy to software and the ability to use things like copyleft licenses, so that instead of just putting software, or in the case of synthetic biology, putting parts into the public domain, you can put conditions on them so that if someone is modifying, making changes, the same distribution conditions go along with those, with the modifications. So there's a desire for that kind of control. It's not at all clear that copyright protection is going to be available, and I'll say more about that in a moment. On the patent side, while most synthetic biology inventions are going to be patent eligible, recent cases at the Supreme Courts in the United States and Australia have pointed out that there's some kinds that are not. So in the United States, we had the AM Association of Molecular Pathologists versus Myriad Genetics case, where the Supreme Court said that isolated genomic DNA was not patent eligible, and that some complementary DNA sequences also might not be patent eligible if they were not markedly different to something that exists in nature, or were so short that they were basically identical to what exists in nature. And we've actually started seeing patent applications being rejected on that basis, patent applications for some synthetic biology, with synthetic biology claims being rejected on that basis. The Supreme Court decision in Australia, which was DRC versus Myriad Genetics, even though it was interpreting a different statute, came to a similar but arguably broader result in terms of the exclusion of certain kinds of inventions, because not only were the genomic or isolated DNA claims deemed patent ineligible, but also the cDNA claims in that case. That one is far more recent. It's unclear exactly how that decision is going, how broadly it's going to be interpreted in Australia, but it bears watching. An important point to keep in mind is that patent law is territorial, and so although we have these limitations now in the United States and in Australia, other countries do not. And so Europe, for example, the European Patent Convention makes very clear that isolated DNA sequences are eligible for patent protection. So we're now seeing more and more of a difference by country regarding patent eligibility for these types of inventions. Regarding copyright protection and the potential for copyright protection for synthetic biology, in particular for DNA sequences, the U.S. Copyright Office does not have an official position, but apparently researchers have contacted them, and the unofficial position is that they will not register copyright for a DNA sequence. And whether or not that will persist, it's hard to say. It was reported, I think earlier this year, that the company DNA 2.0 had filed an application to register a DNA sequence, and that application had been rejected by the Copyright Office. I spoke to the attorney who is representing them. They are planning an appeal of that decision, and it will be interesting to see what happens with that appeal. Since, again, there's no firm policy. There are arguments for and against. There are arguments that the copyright statute has been interpreted expansively and certainly has expanded over time to include things that might not otherwise be considered literary works like software, and that, therefore, DNA sequences should be protectable in the same way. But there are issues with the fact that DNA sequences generally are performing a function, and if the sequence is dictated, if the form is dictated by the function it's performing, generally that's not going to be copyrightable. Or if there are a limited number of ways to express that particular function, that also would be a basis for saying it's not copyrightable. So this is something that also bears watching to see whether copyright will ultimately be an option for protection for DNA sequences. Okay, so getting back to the synthetic biology and the Nagoya Protocol. The reason for the Nagoya Protocol and its predecessor treaty, the Convention on Biological Diversity, really came from the fact that a lot of genetic material that is used in research originates from countries that are rich in biological diversity and has been taken over quite a long period of time and used. And while that might have been a problem, certain aspects of that were problematic. It became even more problematic in the early 80s after the United States Supreme Court in the Diamond v. Chakrabarty decision basically opened the floodgates to patenting of biotechnology, patents on life. And so there was more of a concern on the part of developing countries that their products, their resources were being put under exclusive monopoly protection in terms of intellectual property, and they were not necessarily sharing in the benefits from that. And this was called biopiracy, this sort of patenting without sharing these benefits. So that led to the Convention on Biological Diversity in 1993, which has basic principles that states have sovereign control over the biological resources within their borders. And states are to conserve those resources, but they are also to facilitate access to those resources, but it should be on terms that are fair and equitable and involve the sharing of benefits with the providers of the resources and associated traditional knowledge that might have led to how to use those resources. So the CBD provides for prior informed consent and access and benefit sharing, but it didn't say how to do it. And so following the CBD, there were countries in trying to comply with their CBD obligations that enacted legislation, and the legislation differed widely from country to country, making it very difficult for researchers to know what their obligations were and avoid running afoul of these laws, some of them with very serious consequences, even criminal penalties in some cases. So there was a need for a uniform framework and a more transparent mechanism for making sure that, for making it easier to obtain prior informed consent and to comply with the access and benefit sharing obligations. And that's the goal of the Nagoya Protocol. As Todd noted, it recently came into effect in October of 2014, and it is basically the framework for the implementing the prior informed consent and access and benefit sharing provisions of the CBD. Among other things, it obligates parties to designate checkpoints where you can determine if a genetic resource has been obtained with prior informed consent, where the proper access and benefit sharing has been taken care of. Countries that provide that genetic resources utilized within their jurisdiction have been accessed in accordance with the laws of other countries, and cooperate in cases where there have been violations. Now that all sounds great. The problem is the Nagoya Protocol, as I discussed in the report, doesn't have much of a compliance mechanism. There's not really much in the way of teeth if there's not compliance. And there's a lot of wishy-washy language in the Nagoya Protocol as well in terms of appropriate things of that nature. So in fact, it's been called a masterpiece in creative ambiguity on topics where consensus was not reached during the negotiation. So I mentioned we talked in the first report about temporal scope and breadth of coverage issues. Other issues that are also not clear and that relate to this are, how far does the definition of genetic resources go, and are derivatives covered, things of that nature. The bottom line is that even after the Nagoya Protocol, countries have considerable flexibility to enact the kinds of access and benefit sharing laws, disclosure of origin laws that they desire. So a lot has actually been left to the national level. And while flexibility is great, it can tend to lead to more uncertainty. And so it would have been perhaps preferable to have more of these issues resolved at the international level. And it's not that it can't be. The CBD, Conference of the Parties, continues to meet every 2 years, and as Todd mentioned, there are these OCTEG, various groups that are studying issues, but these particular issues have not really gained traction yet in the CBD and Nagoya Protocol discussions. Oh, there was the slide. There's my NIGON team. All right, just ended up in the wrong spot. So regarding use and use of digital information, so as Todd mentioned, there really at this point is not the need in many cases for any tangible starting material, and that really is what the Nagoya Protocol, the CBD, they're directed to. Actually coming into a country, taking a sample of some resource and not getting permission, using it, not sharing the benefits. But once you have that genetic resource and once you're able to sequence that DNA and it's uploaded, for example, into a publicly accessible database, well, what then? Is there still an obligation to comply with Nagoya? It's not at all clear. This is complicated by the fact that one of the provisions in Nagoya, Article 8, encourages countries to provide simplified measures for non-commercial use. And this sounds great, okay? So there are lots of organizations that are doing wonderful research about genetic diversity around the world, and we want to make it easy for them to get access to these resources. The challenge is that in many cases, this research is being then uploaded, again, into publicly available databases where third parties can use it. And as I again talk about in the report, there are some possibilities of watermarking techniques, but it seems as though at this point they could be fairly easily circumvented. There's no foolproof way to ensure compliance. I've just got a couple examples there of some of the non-commercial bioprospecting projects that are generating a lot of data and making it available in publicly accessible databases. All right, so let's see. Yeah, so genetic engineers used to cut and paste. Now it's typing and printing and pasting. It's no need for this tangible material, and that's potentially problematic. Problematic because it's, again, leading to concerns about biopiracy. So this is a picture I took at the first meeting of the parties to the Nagoya Protocol in Pyeongchang, South Korea, where Todd and I spoke at a side event, and there was a lunchtime Sin Biopiracy Award presentation, the Captain Hooks Award. And so these issues, and who wants to be called a biopirate? No one does. So how do you avoid that? And how do you the kinds of activities that may be labeled biopiracy? Well, this is the kind of activity that some of these NGOs are talking about. Biopiracy conventionally meant physical removal of a material, but now you possibly can have digital biopiracy. So we need to start grappling with addressing these issues. And it's not just theoretical, it's not just NGOs. There was an opposition to a Monsanto patent that was filed in the European Patent Office in December 2014, and one of the accusations, or at least a characterization, the accusation is that Monsanto is engaged in biopiracy. Monsanto in the application talk about screening, lots of plants, that they claim the usage of hundreds of DNA sequences originating from natural genetic diversity. And actually in my research, I came across I'm not sure, I wasn't able to trace whether this US application was related to that European application, but I did find a Monsanto application where they talk about the process that they use of seeking out homologous sequences, protein sequences, using databases like GenBank. Okay? So is this going to be called biopiracy? It's a challenge. So, and as I was working on this, it reminded me of the file sharing battles that we've seen in the copyright area, music downloading, music and movie downloading, and 3D printing, these same kinds of concern that have the same origin, the digitization of information, that when you make this information available digitally, it's easy to copy, it can be difficult to trace origin. That's going to be harder to trace origin for these kinds of creative works or protectable works than even for movies and music. And that's a problem if it leads countries that are rich in biodiversity to start clamping down on non-commercial research and access to it. There's an article talking about Indonesia's plan to institute a moratorium on foreign biodiversity research because of these kinds of concerns. So there are two problems. We don't want it to be so hard for researchers that they're afraid to access these public databases. They're afraid of the transaction costs or the possible liability. We want people to be able to use the data, but we also don't want countries to limit access to the genetic resources themselves, because there's still so much that has not been examined. An article puts it that only 15% of plant species have been examined for biodiversity. That means there's a lot out there that we still would like to find out about, a lot we would like to know. So obligations in relation to synthetic biology may not come from the Nagoya Protocol. The Nagoya Protocol simply does not address it. There were discussions in some of the meetings leading up to adoption of the Nagoya Protocol, but nothing about synthetic biology ended up in the final agreement. So where we are at this point is the possibility of national laws providing obligations and liability. And I have an example here, not that Brazil, to my knowledge, has interpreted this provision this way, but Brazil does have a provisional act that was originally adopted to provide compliance with the Convention on Biological Diversity. But it defines generic heritage, protected generic heritage, broadly as information of genetic origin. And that's the kind of provision that I could imagine being used if a country so desired to get at the types of digital information used in synthetic biology. So final topic, possible future ABS disclosure of origin obligations. So this is at WIPO. I mentioned this IGC, and someone was just mentioning a long name. This is another long name. So we just call it the IGC for short. My involvement here is I'm providing expert technical assistance to the government of Mozambique in these negotiations, which is giving me somewhat of a bird's eye view on this topic. So there are 3 draft texts that are being negotiated currently at WIPO. And WIPO, the World Intellectual Property Organization, is a United Nations agency charged with promoting intellectual property protection around the world. And WIPO administers a variety of treaties. So this is an effort to create new treaties regarding new protections, new kinds of IP rights. New kinds of IP rights would relate to traditional knowledge and traditional cultural expressions, which I'm not going to talk about. But there's also a text related to genetic resources, which would not be a protection type of instrument, but a transparency mechanism, because its key feature would be a mandatory disclosure of origin requirement for patent applicants, that applicants disclose the origin of genetic resources that are used in developing their inventions. Whether this will be 1, 2, or 3 agreements is yet to be decided. The demandeurs, those who are seeking these new treaties, are mostly developing countries, provider countries. They want binding IP protection or facilitation of access and benefit sharing through the Genetic Resource Treaty. Many non-demandeurs, large developed, mostly user countries, do not want an IP agreement, do not necessarily want a mandatory disclosure of origin requirement, and for that reason it's taking quite a while to get there. Negotiations are in their 15th year now. I've not been involved, I've only been involved the past 2 years, but whew, it's a long time. So why? Why are countries pushing for disclosure of origin? This goes back to that biopiracy concern that patents are claiming genetic material, and these resources have tremendous economic value. The current system of IP rights enables the misappropriation or unfair free riding of genetic resources and traditional knowledge. And IP law currently protects certain types of creative activity, but not other types of creative activity. And that's fundamentally unfair and results in these unequal distributions of ownership, and that this is problematic. So that's what's going on. The interesting aspect of it, though, is that while this agreement or these agreements are being negotiated, disclosure of origin requirements are popping up in countries' national laws. And there are already at least 20 countries with disclosure of origin obligations, and in all likelihood, more will be continuing to show up because of the Nagoya Protocol having now come into effect. And because there's so many countries that have these requirements, a number of industry organizations and even governments are encouraging researchers to comply with prior informed consent, access and benefit sharing obligations, and are putting out handbooks for how to do this. So while Nagoya is not an IP treaty, it has a link with IP because of the patent aspect and the fact that Nagoya, as I mentioned, requires countries to set up compliance checkpoints. Well, a patent office is a logical checkpoint to check for compliance with have you obtained proper consent in using these genetic resources. And in fact, that was discussed in the negotiations leading up to Nagoya. It did not end up being actually in the document, but 2 of the 4 countries that so far have identified their checkpoints to the CBD under Nagoya have identified IP offices as the checkpoints. There are also, and so this is very much a situation that is evolving. Nagoya just came into effect late last year. Countries are still developing their implementing legislation, so we don't yet know what it will all look like. I have an example there, and I talk just a bit in the report about a draft legislation from Denmark that seeks to implement the cooperation provision of the Nagoya Protocol, so providing cooperation against violations of access and benefit sharing laws in other countries, that if you're trying to obtain a patent in Denmark and you violated another member country's access and benefit sharing laws, you're not going to be entitled to a patent in Denmark. It's very possible that we could see other countries who are party to Nagoya implementing those types of provisions in their national laws as well. So let me wrap up. I know it feels like I'm going on forever and ever. I'm almost done. Just an example of how disclosure of origin obligations possibly can work. I think China provides an interesting example. So this is a WIPO graph of the top 5 offices for patent applications. And the one that's way ahead is China. The Chinese Patent Office, State Intellectual Property Office, receives more applications now than any other country, which is particularly fascinating since China has only had a patent system since 1984. So it's a pretty steep curve there, followed by the United States, Japan, South Korea, and the European Patent Office. So China, they get more applications than any other country, and China, since 2009, has had a disclosure of origin provision in its Patent Act that applicants are to give the direct and ultimate origin of genetic resources. If you can't give an account, then just say why. You don't know what the origin is. And if genetic resources are obtained or used in violation of laws or administrative registrations, the patent shall not be granted, therefore. There was an article earlier this year by a couple of Chinese patent attorneys evaluating how disclosure of origin has been working in China. And it apparently is working fairly well, considering how many patent applications China receives. They point out that around between 2009 and 2013, 7,000 patent applications but I mean, we're talking about what, 400,000 applications total. So 7,000, it still isn't that many. And the way the Chinese system works, basically an examiner will request a disclosure of origin form, that you fill out a form. You don't necessarily have to, in your initial application, specify that. So they'll request, okay, disclose the origin. And these are, of course, most of these applicants are from China, but others are from other countries as well. So researchers in the US and other countries are having to deal with these disclosure of origin obligations in other countries where they're trying to obtain patent protection. These Chinese patent attorneys conclude that this disclosure requirement is not placing an undue burden on applicants. However, when I was at a WIPO meeting just a few weeks ago, I was talking with someone from the Chinese Patent Office. And she was saying, they do get complaints about, having to do this, why do they have to submit these forms? So, no one is ever going to be happy, but to the extent countries can implement disclosure of origin obligations that have a minimal or reasonable burden on applicants and on offices, that would be preferable. And that perhaps is a reason why it would be helpful to resolve this or to have some sort of international standard through the IGC that would enhance legal certainty. If there's perhaps a standard way of a standard format for these disclosure of origin requirements, that would make it easier for researchers to know what they're going to need to comply with. I'm not going to do that. So the issue for the IGC and Nagoya Protocol is that the IGC is not yet talking about synthetic biology. The IGC is still talking just about tangible genetic material. It's not talking about digital DNA. And this is year 14, or 15. These issues just have not yet penetrated these discussions, and until they do, it would be preferable, I think, to address these issues at the international level. But if they're not addressed internationally, I fully expect them to, bit by bit, start showing up in national approaches. So what are some of the things that can help? And I don't have slides on this, well, other than this one slide. I do talk about some possibilities in the report. But facilitating disclosure of origin and benefit sharing, how can we make it easier for researchers to comply if these laws start showing up? So Bob Friedman of the J. Craig Venter Institute talked about approach that they've taken with a lot of the data that they've been gathering in terms of putting it in databases and identifying where the information came from. So that's an example of language that was put in the Camera database, and telling users what they need to do if they're going to use that genetic information. To the extent databases include origin, that's going to make it much easier for researchers who are using that data to comply with any obligations. So I'll stop there. It's a lot of diverse and complex issues with very few answers yet. How do we comply with the spirit of the CBD Nagoya Protocol in terms of fairness while not unduly inhibiting research or burdening emerging synthetic biology research? Nagoya was not designed to address these issues, so we really need study and action, preferably at the international level, to minimize uncertainty, minimize transaction costs. But in the meantime, researchers are encouraged to use due diligence to, as far as possible, identify the provenance of genetic material that they're using. The likelihood of future digital DNA obligations are uncertain. Oh, that's timely. All right, so with that, I'll open it up for questions.
All right, well, thanks for that, that great overview. So I'd like to open it up to people in the room who, if you have questions, just raise your hand and we'll get a mic to you. So, back there.
Hi, I'm Bob Sorensen from the Department of State. I'd like to start with a really basic question, which I don't think I've heard an answer to. When you have genetic resources that exist in multiple countries, and as in a species with a range across several countries, does the origin designation just depend on where that actual sample came up, or can other countries make a claim on the same genetic materials? I'm sure you've thought about it, but I don't know if you have an answer.
Right, so yeah, it's a great question. And countries, I would say, well, I think most countries that have a origin requirement want to know where you got it from. Okay, so if you got it from a particular country, but that is something, there actually is an article in the Nagoya Protocol that mentions transboundary situations and says that perhaps a way to address this would be some sort of benefit sharing fund. So you're not quite sure where it came from. It could have come from this country or that country. Make a contribution to the fund, something like what we have in the International Treaty on Plant Genetic Resources for Food and Agriculture. And to me, that makes sense. That also, I think, might be a way to deal with some of these issues if you're using information from these databases. If there's a fund that you could pay into, that certainly would be a lower transaction cost way of dealing with it. But yeah.
Can I maybe expand on that question to you a bit as well, in terms of, and it gets to the derivatives question. So if you're only using, say, a component of a genetic sequence, how does that sort of work under the Nagoya Protocol as well, right? So if you're only taking, say, a promoter, for instance, that may come from an indigenous species from a particular country, how does that work from the access and benefit sharing component? And sort of similar to that question, what if that same promoter also shows up similarly in another indigenous species in another country? Is there any thought on that, or are any of the countries that have sort of started this process begun to address that at all?
I have not seen that particular issue being addressed yet. I mean, and as we've talked about before, you know, the question of derivatives under the Nagoya Protocol is itself somewhat controversial because, I mean, it's mentioned in the definitions, but not in the active articles. So, yeah, I'm not sure.
Thank you. Gladys White from Georgetown University. You've talked about patenting and you've talked about copyright. What about trademark? And the reason I ask is because the watermarking strikes me as equivalent to a kind of branding that we might associate with trademark. Can you speculate about trademark as a possible way of protecting digital information and property related to genetics?
So that's an interesting question. I must say I had not thought about watermarking in the trademark context. So trademarks generally have a use in commerce requirement. You need to be using it commercially. But so if you are putting this watermark in and you're saying this is your trademark and arguably you're doing it for a commercial purpose, I guess that could work.
If you're doing it as a way to designate authorship.
Yeah, the use requirement, I'm not sure that that would be met. I'm thinking, of course, of U.S. law, U.S. trademark law, in terms of right. So to register a trademark, if it's for goods, the mark has to be used on or in connection with the goods, and the goods have to be transported or sold in commerce. So those are the I think the issues that one would run into with trying to use it that way. But you know, I think trademark law has been expanding just like every other area of intellectual property, and it is malleable. I would not call it quite a nose of wax, but I think it's worthwhile to do some additional thinking about that, and I just haven't. So I would like to do that. It's funny you should ask that. I just finished teaching a trademark course and writing a trademark exam. I'm like, ooh, can I use that? So I'll have to give that some more thought. But I think that is interesting, and I'm wondering if those hurdles could be overcome. Yeah, sure.
Hi, I'm Ashley Bear from the National Science Foundation. I have a question. It may be a little out of scope, but I was thinking about, so in our programs at NSF, we have a lot of digitization of museum collections going on, and it got me thinking about if many of these collections were collected in other countries historically, but now are the property of a museum. But if you were to use those museum collections to extract genetic resources, where are sort of the legal lines around something like that?
Yeah, so that's gets to the temporal scope issue that we discussed in our first report, and that's something that countries differ on. And Nagoya, they punted, and so they did not specify whether the obligations of the protocol only apply to genetic resources that are accessed after the protocol comes into effect, or after the CBD came into effect, or at any time in history. And so countries differ on whether there is an obligation. Some say, no, this to really give effect to the spirit of the CBD in Nagoya, it needs to be accessed at any time, but if you're utilizing them now. So this to utilization being looked at as the new access. So yeah, you're accessing it now, and so that's the time that we're looking at. And so that varies. The EU, for example, in their regulation directive implementing Nagoya, they take the approach that the obligations only apply to genetic resources that are accessed, and that means crossed a border basically, after the Nagoya Protocol came into effect. So those collections that you're talking about would not be a problem under the EU regulation, but in some other countries, yes.
I have a couple of questions for you,
Oh,
if you don't mind.
okay, sure.
First,
Well,
take this one first, and then we'll come over to you.
oh, well,
I can yell too. I was waiting on using our protocol here of the microphone.
I'm Maggie Kozel from Georgia Tech. I'm really curious about this phrase that you used, a masterpiece in creative ambiguity. Historically, international treaties, protocols, conventions that are characterized of such creative ambiguity, how effective have they turned out to be? Because I can hand wave it either way, but I'm curious as to what the historical record would suggest.
So I'm quoting there. It is in quotes. I did not create the term. But so creative ambiguity is what we see in lots of treaties, as I'm sure you know, when parties cannot agree. You put in some language that leaves the flexibility for folks to do what they want because you ultimately want to get to agreement, and you're not going to get to agreement any other way. So yes, this is not new to have that kind of ambiguity. I guess if we want to look historically at Where it makes a difference is if you have an agreement with teeth that actually has a compliance mechanism, like the WTO TRIPS agreement, for example. The ambiguities there, it matters how they get interpreted, because if you are found not to be in compliance, there are some serious trade sanctions that can be imposed. But yes, arguably it doesn't matter so much if there's not much that's going to happen to you if you don't comply.
Yeah, so the other one I would think of would be the Biological Weapons Convention, which again has no implementation.
Yeah.
I do have a little bit of anecdote to go with that answer, because that, I understand groundwork was not really laid that well for the negotiation. It was in Japan, as you can imagine, and the Japanese are both very good at ambiguity and very desirous of reaching an agreed outcome. And so that this particular agreement had even more ambiguity than
Yes.
usual.
Yeah.
Sorry to play on cultural stereotypes there, but that's kind of how I understand it.
No, you're absolutely right. I've read reports of it, that it was a very last minute, and the Japanese delegation put forward this as a kind of a take it or leave it text, and yeah, let's do it.
Hi, I'm Bruce Manheim with a law firm called Wilmer Hale here in town. And I work with companies on implementation issues and compliance issues with the protocol. So I have two questions. First, this concept of genetic information, which is embodied in the provisional measure for Brazil, and I think is also now in the new legislation that Brazil enacted in May of this year. Have you seen that in other provider measures, or for that matter, in user measures like the European Union regulation that was adopted a year and a
Right.
half or so?
I don't believe I've seen it in the EU. I feel like I've seen it in a couple of other countries. I feel like the Andean communities has something, but I have not. That's just anecdotal. So, yeah.
And then my second question is, since the U.S. has neither ratified the CBD or, for that matter, the protocol, what are the implications of all of this for a U.S. company that's doing research and commercialization in this area?
So that's a great question. Certainly, there are not going to be obligations in terms of U.S. patents, but of course, lots of companies are trying to obtain patents in other countries. And so these laws show up both in biodiversity laws and often in IP laws. And so if you're trying to obtain an IP right, it could affect your ability to obtain that IP right or the validity or enforceability of that IP right in that country. But it could have other penalties, even simply from the access and benefit sharing, even if you were not trying to obtain a patent in that country. Moreover, if we see countries take the approach of Denmark, and again, I don't know that Denmark, if that provision will show up in its final legislation, but if countries do in their legislation agree to cooperate and say that if you have violated a law in this country, you can't get a patent in our country, even if you weren't applying for a patent in that country, then that could have an impact as well. So yeah, I always use the example of the Indian Patent Act and the Indian Biodiversity Law, where just filing a patent application based on genetic resources obtained in violation of the Biodiversity Act has criminal penalties associated with it. So that applies to U.S. researchers. If you are using Indian genetic resources, it applies to anyone.
And would that apply where a patent application is filed in Europe or
Anywhere, yes. Mhm. Right, so just don't go back to India.
When you were talking about the U.S. Copyright Office, I found that really interesting, and around the question of whether it's a work of literature, I think was the term you used. And so what's your thought on, so since we're now sort of moving into this realm of actually writing DNA and then synthesizing it, can you envision a sort of world in the Copyright Office where someone writing DNA, particularly if we get to the sort of the promised land of synthetic biology, right, where we've written a completely new sequence, if then that would potentially change the Copyright Office's thinking about whether it would be a work of literature?
Yeah, I think it's possible, and I wish I could remember the example, but Andrew Torrance wrote an article about the copyrightability of DNA. So Andrew Torrance, Chris Holman, they've both written articles arguing that DNA sequences should be copyrightable. And I think it's Andrew who has an example of a researcher who actually did write like a story or a game using DNA base pairs. And I mean, so it had no function. It was, you really are just, and the idea is that this is the type of expression that certainly should be copyrightable. And arguably, it should. I am wondering if the approach of the Copyright Office to DNA sequences is like the approach of the Patent Office back in the 70s to software. So back in the 70s, the United States Patent and Trademark Office did not want to deal with software. They did not want to examine software. They're like, no, that should go somewhere else, copyright or somewhere else. But over time, they hired computer programmers, they developed capacity, and ultimately software with various decisions became patent-eligible subject matter. I don't know to what extent the resistance of the Copyright Office is related to an inability to handle, a belief in an inability to handle this subject matter. Just recently I read an article where Maria Palante, the Register of Copyrights, was testifying before a congressional committee that the Copyright Office needs more techies. They need more people with technical backgrounds to help. They don't just need file clerks. And it made me think, I wonder if they're thinking about the possibility that down the road they may actually have to start providing protection for DNA sequences. I think it would be hard to maintain a blanket exclusion to say that it's not possible for DNA sequences to meet the copyright standards of originality, fixed in a tangible medium of expression, and that there might be some who have sufficient aspects that are not dictated by function, where there is some ability for different expression, that they could be protectable. So it remains to be seen, but I'm not sure how much is just, we don't want to deal with this because we're not set up to deal with it, as opposed to a fundamental, this is not copyrightable.
If I'm filing
Sure.
Rena Singh, Biotechnology Industry Organization. So if I'm filing an international patent and I'm a U.S. inventor, of 5 countries out there, one of them happens to be China, and I will be asked those questions, right? So, okay. If for whatever reason I'll sort of disclose that, I got it from South America, one of my sequences, what happens then? Does China kind of tell me, well, you go and give some sort of compensation, or what happens?
Okay. So yeah, that's a great question. To my knowledge, no patent office is, and I certainly have not examined them all, but I'm not aware of any situations where patent offices are taking the next step of actually analyzing what it is that you've submitted to say that you need to comply with some law or whatever. Okay, so, and that is a burden that patent offices have been pushing very much against, that they're like, we don't have the capacity, we don't have the training to make evaluations. I think at most what we will start to see is that information being made publicly available so that countries that are interested can search patent office databases. And so that's what I think the DOO, the disclosure of origin requirement, is supposed to be. It's just supposed to facilitate transparency. Not put a burden on the office to do something else. Now, there could be a requirement within a particular country that when you get a disclosure form like that, that maybe that would get transferred to a different office, a National Biodiversity Office, whatever, for follow-up if the resource came from that country. And China, I believe, China is particularly interested. China's law, I don't believe, the way it's interpreted in the regulations, as I recall, it's not using genetic resources from anywhere. It's using genetic resources from China. So you have to disclose that you got them from somewhere else. But the penalty, I believe, is only if the genetic resources came from China. And there are a number of countries like that, their laws are designed to make sure that there has not been a violation in relation to genetic resources from those countries. Now, again, as Nagoya continues to get implemented and Nagoya takes a broader view that you need to not only focus on your country, but on whether people have complied with other member countries' obligations, we might see that change.
Thank you. My name is Yu Zhao from Public Citizen. Since you mentioned China, I've seen a law firm publish an article talking about like the burden is, the disclosure burden is not upon applicant, but they suggest like you disclose the genetic resources for the initial application. Otherwise, if the office asks you to disclose it, they may like reject you because you are not qualified for enablement. So,
Oh, yes.
yeah. So, how much do you see like the disclosure affect the patent office, the decision of them? Like, if you don't disclose it, they may like reject your application. Maybe just not in China, but in general.
Right. That, to my knowledge, is very rare. So as I said, there are so far around 20 countries that I've counted that have disclosure of origin requirements that have some penalty associated with them. I mean, technically, the EU Biotech Directive says you're supposed to disclose the origin of genetic resources, but there's no penalty if you don't, so I don't really consider that disclosure of origin obligation. But of countries that have some sort of penalty, even if it's outside of the patent system, generally these are smaller countries that simply don't get that many applications. So, we've got the examples from China, and that same article that I mentioned, it said that it was a very small percentage of applications that were actually rejected after that, and I don't believe those rejections were based on, from what they said, were based on information in the disclosure form. I've also seen information from Switzerland. Switzerland has a disclosure of origin requirement, and the Swiss, you have to disclose origin in your application. If you don't, the application will not continue to be processed. If you disclose and you lie, you go ahead and get a patent and they don't know that you lied. But later on, if it turns out that you lied, that's punished outside of the patent system. It doesn't affect the validity or enforceability of the patent, but basically it's like a perjury penalty. So you would be punished under the law basically relating to lying to foreign officials. And so Switzerland, most of the there are just not that many Swiss national patent applications, and then an even smaller number that are going to deal with genetic resources. So it just doesn't come up that much. But their experience so far, I don't believe that they had any rejections on that basis. So it raises an important question, because that's why the disclosure of origin requirement really is seen more as a transparency mechanism, as opposed to a provision to prevent the erroneous grant of patents, because source, generally, I think it will be unusual for it to create an enablement problem. China does have some pretty stringent enablement laws and requirements in terms of what you have to have in your application as filed. That differs from many other countries. But yeah, most of the time, it might help an examiner to search, to know the source of this information to search, but it normally should not affect things like enablement. If it helps the examiner to find some prior art, then sure, that could be a basis for a novelty and non-obviousness rejection, but maybe it will, maybe it won't. Yeah. Yes.
So I have a follow-up question on that, particularly from Public Citizen. How about the pre-grant and post-grant oppositions? Like, you know, because the enablement requirement, it's like, it's not very effective in practice. But I think like more and more countries adopt like enablement disclosure requirements, like the civil society or the other companies that can use that for pre-grant if there is a pre-grant opposition system in the country or during the post-grant opposition. So what's your take on that? Or has it been used? Like
Right. I can't say that it has not. I can only say that I'm not aware of a post-grant proceeding being based on lack of disclosure of origin.
My question is about the IGC negotiations. And so with your experience, why is there such an avoidance on talking about the synthetic genomics? And is there a concern that, you know, once or, I mean, after 15 years, once or if they come to a conclusion on physical misappropriation of genetic resources, would that become more obsolete in the popularization of digitizing these genetic resources?
So, and Stephanie's one of my former students, and Aisha, I'm so glad they're here, now practicing attorneys. So, it's true that the negotiations have been going on for 15 years. They've only been doing text-based negotiations since 2009, which is still pretty long. And I don't know that I would say that it is an avoidance of the issue, but that it's just not something that people really have been thinking about, and there's been so much disagreement just in relation to tangible genetic resources that to bring in this issue, I honestly don't know what will happen with that. So there is a lot of, the negotiations just move very slowly for a variety of reasons. And I mean, there's still lots of disagreement on the meaning of a beneficiary or on misappropriation or the definition of traditional knowledge. You know, lots of basic definitions have not even been really addressed. So hopefully, now that the IGC negotiations are starting up again in February, I believe, it's expected that greater progress will be made, especially on the genetic resource text, that is the one that is the farthest along. Whether synthetic biology and digital information will come up, I'm not sure. And I'm not sure whether I even hope that it does. I mean, in a way I do, but I'm like, oh, that's just going to make it even longer. But it probably would be good to go ahead and address it. So, but I mean, a lot of countries they're not thinking about these issues yet. I mean, if they're not thinking about them in the CBD, I mean, they're thinking about them, but not this level, you know, then they're not going to be thinking about them in the other bodies.
So a follow-up question I have is, what about more pressure to the genetic databases themselves? I know you say that some require the disclosure of origin, but if their overall aim is to promote an open source and transparent environment, then wouldn't it be better off for there to be some sort of agreement between the genetic databases to have this disclosure?
Yeah, I absolutely agree. I was looking at some records in GenBank, and I'm like, you know, it doesn't look like it would be too difficult to add, you know, a source field, but there needs to be someone who presents that, and there needs to be some, you know, pressure for that to actually happen. So yeah, I think that would be definitely facilitate if the big databases proactively encouraged or required source to be disclosed when these DNA sequences are being uploaded. You know, these issues, another thing I'm finding is that it tends to be compartmentalized, and people will think about it in one context and not think about the potential ramifications in another. So I've been running across articles where, you know, researchers even from these developing countries they're publishing their research, they're uploading DNA sequences into GenBank and not thinking, oh, you know, or maybe just not aware. You know, so it's the issues are evolving. So much is happening all at once, and there's no one that's really looking at, you know, it holistically and saying, you know, there really should be consistent policies to deal with the different ways that this information gets disseminated, and making sure that, you know, the proper controls are in place, or thinking about ways to, again, facilitate access in a reasonable manner while still having possible benefit sharing of some sort. And then again, I do think a fund might, in these database cases, might be a better way to go.
Yeah, I have a comment and a question, I guess. One of the compartments in which this is an issue is the pandemic influenza preparedness framework, which I guess a couple of you may be familiar with, and which is being reviewed during 2016. And one of the items on the agenda for review is how genetic sequence data are to be treated under the framework. That question was discussed during the negotiations in 2011 when this thing was put together, and basically put off until 2016. And since then, of course, we've had companies become able to create a seed virus for a vaccine out of the genetic sequence data. The framework deals exclusively with human influenza viruses of pandemic potential. Sorry, let me correct myself. With influenza viruses of human pandemic potential. So it is really very much a niche, but it's also, I think it's uncharted territory how we're going to come out at the end of the year with that question. There's been discussion of a traceability mechanism, which we're not sure is very practical. I mean, I think our opening position is kind of like, there's not really a problem here. Any pandemic virus, you know, we already have a scheme for providing benefits based on the use of these pandemic viruses, and it will apply just as well with the genetic material. And I think that's probably true in this case, but I'm not sure that everybody's going to be happy with that precedent. So it's, you know, it's really a wide open question, and one of interest, I think, perhaps wider than the niche it's being discussed in. The question I had was more on whether you're already seeing reactions to the increasing utility of genetic data in terms of attempts to restrict those scientists you mentioned, just plain uploading their data to GenBank without any control or regulation by their national authorities.
Yeah, and I have not yet. Not saying it's not happening, but no sign yet.
Just want to thank Margot again for being with us today, and also doing all the research and producing this report for us. And so with that, I want to thank everyone else who's here in the room with us and on the web. So help yourself to coffee and snacks that are outside, and thanks again.
Thank you. Thanks so much. It's really been fascinating to research.
Yeah, it's
I just keep digging. I keep